All right, good morning, everyone. We like to get started on time. We have quite a few people still joining. My name is Paula Hyman. I want to welcome you to the final installment of the Acquisition 104 Instruments course. I'm filling in for Victoria Beal today from the Ohio LTAP Center. Before we begin today, I just want to cover a few housekeeping items just as was done in the previous sessions. If you have questions throughout this presentation, I ask that you please type them into the questions box. To locate that, just go find the little caret that says questions, click it, it'll open up the box for you. And just go ahead, everyone, and type in a hi, a hey, just something so that I know that you know how to use that box. Presenters are going to address your questions periodically throughout the presentation. So that way we do not interrupt them. So if you have a question while this session is going on, just type it there. This questions box will keep a record of any question that's typed in there. So things that aren't answered right away do have the opportunity to be answered after the presentation is completed. Lastly, there are handouts available to download in the handout section, and that's right below the questions box. If for some reason you are unable to download any of the attachments, if you will, just put that in the questions box, shoot me a message and with your email address, and I will get that out to you if you need it right away. Otherwise, after the session, this information will be emailed to you. And with that, I would like to thank you in advance for your participation, and I'm going to hand things off to Wayne Pace.
Thank you, Paula, very much.
You're
Good morning,
welcome.
everyone. Today is our last session of our Acquisition 104 of Instruments, and today we're going to be listening to Greg Severance. Greg, are you there? He
I'm
shows up
here,
again.
so I've appeared again. And to those of you who are extra observant, yes, I am wearing the same shirt and tie I've done on the other three ones, but I do change out of this, and I don't wear it for 4 days straight or sleep in it. So, no,
Thank you for your wife.
yes, exactly.
All right, let's get rolling, Greg. Today is going to be a little bit more of a shorter session that we've normally had because we've covered so much, and today is going to be a little bit of lighter session. Here's our agenda for the day. We have when dealing with cemeteries, when dealing with partnerships, when dealing with corporations, when dealing with trust and trustees, dealing with powers of attorney, and we're going to have one of legal entity summary. And that legal entity summary, we've already provided you a handout with that, and Greg is going to be providing a summary of each of those areas when we get to that part of our slide. Okay, with that being said, Greg, there you go.
Great. Well, here we go. We start with the cemeteries, which can be owned by a variety of legal entities and generally are. Cemeteries can be quite unique. Usually they have authorized officers to sign the instrument. Some cemeteries are even privately owned. There's a lot of rural cemeteries that are run by townships. So that's what you'll tend to run into, and they may have a trustee that's the authorized officer to sign off on some sort of instrument if we have a taking from the cemetery. And of course, this is laid out in ODOT's Policy and Procedure Manual 5402.11. So oftentimes you will need the assistance of the Ohio Attorney General's office for that, just because it tends to be a unique situation, present unique problems. And of course, we don't want to impact cemeteries as little as possible. It's very difficult. It's the most intensive use of property, and therefore typically the most costly property to acquire as well. Let's see, what's the next slide? It's well, the name. All right, now we deal with partnerships. Name of the partnership as it appears in title report is to be put in the granting clause of the ODOT instrument. The partnership would be the grantor. The acknowledgement for that is RE248I. That's the form. The name of the general partners are entered where the subscribed by appears, because the general partners, or at least one of them, will be signing the instrument. Only general partners need to sign the instrument. As we discuss later in this session, what partnerships are like and the difference between general partnership and limited partnership and the authority of the partner. So the second part of this presentation will probably be the longest, and I'll try to summarize it because there is a PowerPoint presentation that goes along with it that we won't be presenting here. It'll be largely me just talking to you in a summary form. And a lot of this stuff you guys already know. If not the legal niceties of it, you will know by, having run into this before, or just, from what I tell you, it's not that difficult. You look for who really is the person that has the authority to sign off for the particular organization. And here we have an example of the acknowledgement for a partnership. So let's go to the next slide. When dealing with corporations, in order for a corporation to convey real estate, its board of directors must adopt an appropriate corporate resolution. So that's what you'll need to see in order to know who in the corporation can sign on behalf of the corporation. And again, the RE247I is the acknowledgement form. And some corporations do delegate specific authority to officers, or maybe an employee of the corporation, somebody that's their real estate person, may actually have the authority, but that corporate resolution should say who that is. If the articles of corporation fail to designate specific individual to sign the instrument, ODOT must request a resolution that identifies the officer or individual who's authorized to complete the transaction on behalf of the corporation. A lot of people form a corporation, and when it's small, they don't think of all the little niceties and technicalities they have to go along with. But one of those is you got to do a resolution to say who can sign on behalf of the corporation. That's important. And they should have run into that before if they've been, transacting business with anyone. Provide assistance. Assist the owner with the required RE230, ODOT's corporate resolution. That's an example that they can use. The burdens on the corporation to demonstrate the person has the authority to sign for the corporation. It's not for you to guess it. It's for them to show who has the authority. So the next slide shows the example of acknowledgement for corporation. And that's name of the agent, as you see, and then the authority of the agent. In other words, are they the secretary of the corporation? Are they the treasurer? What are they? Are they the CEO? What is their title, basically, because that's where their authority comes from. Let's see, what do we have next? Yeah, resolution. There's the example of a resolution. So if somebody needs to go, well, I've never done a resolution. Well, here it is. Here's an example that they can take a look at. Obviously, this thing's not set in stone, and may be more difficult than what they need to go with, but this is a good example and a good workable instrument for them to go with. Again, somebody that's been doing this for quite a while for a corporation, they'll have their own type of thing for the resolution, and you wouldn't have to worry about it. It's more for the smaller corporations like Ma and Pa type of corporation that you have to worry about showing an example. Complying with ODOT's procedures when dealing with the trust and trustee. In general, the power of a trustee is limited. Okay, that means that they don't necessarily have, complete control over everything, but the trust agreement itself must clearly state that the trustee has the power to convey real estate. If it doesn't state that, then the trustee has to apply to the court and receive permission to sell the property and to sign ODOT's instrument. And then there's an example that comes next, how the trustee signs. And again, they sign as a trustee. That's the thing. It's not as an individual, but as the trustee for the trust. So it's very important when these trusts are set up. And a lot of these things, are typically done by attorneys, but sometimes people can Google the stuff and figure out how to do it themselves. There's LegalZoom, there's all sorts of things. Not that I'm recommending that they do that, but a lot of people will be, they're looking for an inexpensive way to do their legal organization, and they may kind of come up with this themselves. Hopefully they've done it right, because like we said, in that trust agreement, there should be something that gives a particular person, a trustee or a managing trustee, the authority to convey property. Okay, the next section, acknowledgement form selection. If the name of the trustee is followed by the word trustee, then form RE244I is used. There's an example there. John Smith, trustee of the John Smith Living Trust. Trustees to sign an ODOT instrument. If the grantee in the instrument conveyed property and trust and the name of the trustee is followed by only the word trustee, then ODOT does not need to inquire further, because the trustee does have the power to sell. And so there's an example again with the John Smith Living Trust. And let's see the next slide. Yeah, before the property is conveyed, well, let's see, the trust agreement must be recorded. That's because anything that wants to convey property should be recorded at the recorder's office. So that indicates any interest in property. Just like with a power of attorney, if that power of attorney gives the person that holds it the authority to sell real estate, that needs to be recorded. Not that it's an interest in real estate, but it's an authority over real estate. So you want to ask for the trust document. And if not available, at least a memorandum of trust or trust affidavit will need to be prepared and recorded. And that's recorder's rules. That's not ours. That's not something ODOT says. It's what the law basically says. So complying with ODOT's procedure when dealing with power of attorney, as I said, owner of record may authorize another to convey real estate and execute the instruments. You may see this a lot of times with military families that, the spouse is serving maybe over in Afghanistan or something for a period of time. Well, then the spouse that remains in the States typically will have a power of attorney to sign off for that spouse that's in the armed forces and serving overseas. You tend to see that probably the most of almost anything with a power of attorney, that we run into. The authorization may be a general power of attorney or specific power of attorney. The general power of attorney is generally to do all acts that the other person would be authorized to do. The specific power of attorney is to do a specific act. Like sometimes you've heard of a health power of attorney or healthcare power of attorney. That's in order to sign off at the hospital to get medical help for the person that's there and possibly indisposed, and they may be unconscious and can't sign for it themselves right now. The original power of attorney must be recorded in the county the property is recorded in, where the property is located. Again, that is because you're dealing with real estate, then the power of attorney has to be recorded if it deals with real estate and wants to sign off on a deed. If the power of attorney has not been recorded prior to the execution of the ODOT instrument, this process will have to wait until the power of attorney is recorded. It doesn't take long. You just show up and do it. So I'm not sure now if you can record things online for that. It may be possible to do that in a lot of counties. The acknowledgement form to be completed is the same as for the actual grantor owner, but with remarks added to identify the attorney in fact, and that he or she is signing by virtue of a power of attorney. In other words, they're not signing in their own name, they're signing on behalf of somebody. If the grantor is a married individual, probably the most common situation involving power of attorney, the RE 244-1 or -I, excuse me, is to be used. And we have an example of that. The name of the grantor by the name of the person holding the power of attorney that has the power to do that. Let's see. So next we go to the legal entities summary.
And actually, Greg, with this one here, you can take your time. We have plenty of time that you can expand on this. We got at least 45 minutes, so you can go ahead and do your summarizing of this particular.
Well, don't encourage me, Wayne, because it'll end up taking an hour and 45 minutes. Nobody wants that. So,
well, it gives
so
you
if we
plenty
get done
of time.
early, fine. If I go too fast, remember, people, there's the chat room that you can ask questions on, and for those of you that haven't been able to open up what essentially it was a PowerPoint for several other presentations I had done. In particular, I did it for what was it, ODOT's Real Estate Summit last year. I believe it was in the spring or
Back
early
in June
summer.
last year.
Yeah, early summer, I think, of last year. And then after that, I did it at an IRWA organization meeting, the International Right-of-Way Association, which some of you may be familiar with. It's a good organization and a good way to get a lot of information on the cheap, in a sense, if you will. And it used to be that we met locally, at least, at the Der Dutchman restaurant, and you typically got a nice buffet luncheon out of the thing, when you attended. But now, with the virus going on, all those type of meetings are done, and particularly buffets are frowned upon. So, for yesterday, but some days that'll come back. It'll happen again. So, with that, the key to my presentation really is all about the authority. Who has the authority to sign? And as you see, there's a number of different legal entities that will cover the partnerships, corporation, an LLC, which is limited liability company, trust, which we've mentioned already, and government entities. And the key to all this is, as at the top of this page says, agency and authority. So an agent is basically somebody who's working on behalf of a principal, which happens quite often. As if you think of it, real estate, it's called a real estate agent. They work on behalf of a real estate broker. The broker typically is the principal, and the agent, the real estate salesperson, is working to sell the property, and obviously the broker is the one that holds the overall license. Every agent has to work through a broker. So many of you who are experienced in the real estate field know that and have experienced that type of situation. So it's no different in just about any other field as well. That the principal is the controlling person, the agent works on their behalf. And the key to that is to make sure that that agent has the authority to do what it is that you want them to be able to do, which is to sign off on an instrument, the authority to convey the property. So expressed authority is clearly stated. Typically, you'll see a document like a power of attorney is an express authority. That power of attorney makes the person that holds the power, the attorney in fact is the agent for the principal that gave them that power of attorney to act on their behalf. Now, and oftentimes it can be either orally or in writing, but obviously when we're dealing with real estate, it's got to be in writing. An example of oral authority is when you give your spouse authority to, hire a contractor or whatever. That you are one of the principals. The spouse is acting as an agent on behalf of both of you. Happens all the time in my house. Let's see, apparent authority is also known as ostensible authority, and it exists where a principal's actions could result in a third party as a reasonable person, not as a complete fool, but a reasonable person believing that the agent had authority. Here's a good example of what would be ostensible authority, if you would, or apparent authority is often what it's called. And we talk about implied authority too, which would be usual authority. The owner of a store has employees. Those employees often are the people that actually ring you up at the cash register or whatever. They're the agent for the owner of the store. So the owner of the store is the principal, but of course they have employees that have the apparent or implied authority to conduct the sales. Whereas somebody just wandering through the store doesn't have that authority. But, if the principal acts in such a way that leads you to believe that virtually anybody walking through the store could do this, then that's on the principal. That's why they should, that's why people typically have name tags or whatever, or it's pretty obvious. There's uniforms or something, just from the nature of the people, that they're the ones working there as the agent. I was walking through Lazarus downtown one day in a suit, and somebody stopped me to ask some questions. They thought I was an employee there. So I appeared to be an agent, but I certainly wasn't. So I did not work for Lazarus. Okay, and legal entities, again, we talked about that. Typically, let's see, ratification. Here's something else that may happen. It's possible that the apparent agent really didn't have the authority, but if it was a good deal, then let's say your spouse decides, somebody shows up and wants to buy your old broken down vehicle, and they say, well, I'll give you $1,000 for that, car. Well, your spouse may say, hey, that's a good deal because my, spouse was thinking about junking the thing for $500. $1,000 is pretty good. So, okay, that sounds good. Well, they may have set up that contract. They've agreed to a deal. Well, the other spouse comes home and is told that, hey, I just sold your car for $1,000. Is that all right? And the spouse says, yeah, that's great. That's ratification. So we do talk about general agent in real estate is an agent who can perform any and all acts that are associated with the ongoing business that the principal has appointed the general agent to act in. As I said, hopefully a lot of you have come across that. So it's pretty obvious. As we said, the broker is typically the principal, and the agent, the sales agents, are really essentially working for the broker, if you would. Often you'll see an agency agreement. It's a legal contract creating what's called a fiduciary relationship, where the principal agrees that the actions of a second party, the agent, binds the principal to later agreements made by the agent, as if the principal had made those agreements himself. Power of attorney is a perfect example of that. The person authorizing the other to act in their place is the principal or a grantor or donor of the power. Typically, you'll see it as a principal. It's a commercial concept, agency and authority. It's very enforceable. It's, as I said, typically by contract, typically by agreement. Certainly in our situation, we want to be assured that that agent has the authority. So that's why we look for writings, such as a corporate resolution, the officer of the corporation that has the authority to sign on behalf of the corporation. The corporation is the principal. the officer is the agent of the corporation. And the key to that is the agent has authority to contractually bind the principal. In other words, if the whole deal goes south, you're not typically suing the agent, you're suing the principal. The principal's the one who made the promise, even though the agent was the one that you dealt with. So with partnerships, as I said, we've talked about that somewhat. Partnerships, though, are a little bit trickier in the sense that there are two forms typically of partnerships that you see. Anybody can be a partner in a partnership. Even a corporation can be a partner in a partnership. It could be two corporations that are partners. It could be a corporation and a real life individual. It could be a combination of those. Partnerships that you tend to see are called either general partnerships or a limited partnership, or there's also a thing called limited liability partnership. And there's a fourth type that we don't really see in the state of Ohio, limited liability, limited partnership. And it's not recognized in all states, and we don't really see that in Ohio, but it's possible if you're dealing with somebody from out of state or something, an out of state partnership, they may have something that you just haven't seen typically. And again, if it's something that raises a question you're not sure of, check it first with your manager, and then the manager and perhaps you as well together will get online with the Attorney General's office to figure out what the heck this thing is. Because again, the whole key to it is who has authority to sign off on a conveyance form for us. We don't want to get the wrong person.
Hey,
Yeah,
Greg,
Wayne?
just want to pause real quick and find out if Paula have received any type of questions at this point.
Sure, that's a good idea.
Great, thank you. No, there are no questions in the questions box. However, if there is a second set of slides, you can email to me, Wayne, because we have one user who was unable to, who's unable to see the presentation but can hear us.
Okay, we'll be able to do that.
All right, thank you.
All right, Greg.
And again, a reminder, which hopefully will remind you again at the end of this whole thing, that you can send us emails with questions too, because maybe the questions don't, occur to you right at this moment or whatever. This webinar is also being recorded, so you can check it out again if you're all that fascinated with it, or if you feel that you missed something or that something may be clarified, if you, check through it again. Hopefully that works for you. Partnerships, to go quickly back to that, a general partnership is one where all the partners are basically equal. And a partnership agreement should be in place and should be in writing. Not always, though. In a sense, think of a partnership too as spouses, husband and wife or whatever. That's actually a partnership in marriage. Now, is there actually a partnership agreement there that designates who has authority to do what? Typically not. So real life partnerships sometimes can be the same way. It could be a father and son, or again, husband and wife are partners in a business or whatever. Maybe they hold property together. In a sense, they're partners in holding that property. But it may require, again, if they're both on the deed, you got to get both signatures. In a typical partnership, it's possible that one general partner can bind the other general partners. So that's the key for general partners to watch out for. That's why typically a partnership agreement should be created so that each partner knows what their responsibilities are, what their payment's going to be, what their investment in the partnership is, that type of thing. Sometimes people don't want to show those things, but the only thing you need from it is who has the authority to sign off on behalf of the partnership. and it may be every single partner in a general partnership. In a limited partnership, what you've got are a different level of partners. You'll have at least one general partner that essentially runs the whole show. The limited partners have limited authority, typically no authority, because all they are essentially investors. They kicked in some money. And the reason people do that is because, one, they don't want to run the business. They don't want the responsibility or the trouble of doing that. And two, they want to limit their liability to simply whatever they invested in the partnership. I mean, that's up for grabs. It could be lost. But in a general partnership, a general partner can be sued for personal assets. It could go beyond the partnership assets. So that's why partnerships, generally work for a smaller type of business, but once the business starts to grow and has the possibility of getting greater liability against it than maybe what a simple insurance policy or whatever could cover, then they'll tend to go to a different form of business organization, such as a corporation, to try to protect the individuals from liability, financial liability. The limited liability partnership, again, is a kind of a hybrid partnership, and essentially it's another type of limited partnership. That's all it is. But in any partnership, whether it's general or limited, you have to have at least one general partner. Not all the partners can be limited partners. It is the advantage of partnerships is it's probably the simplest way to set up a business. One of the disadvantages is that or it could be an advantage either way, the tax benefits, in a sense, with a partnership, income to the partnership is income to the partners. So it's taxed just one time as income to the partners, however that is split up, however that income is split up. Again, in a partnership agreement, what you're looking at, it should set forth the names of the individual partners, should state the purpose for which the partnership is established, should state the principal place of business, outlining the amount of money each partner invests in the enterprise, and it establishes directives. Again, it should state that it won't necessarily identify limited partners, but it will definitely identify who the general partner is, because limited partners sometimes can come and go. And oftentimes they're supposed to be recorded, but that sometimes falls by the wayside. Now, the comparison with like an LLC, a limited liability corporation, which is kind of a hybrid between corporations and partnerships, instead of a partnership agreement, it will have an operating agreement. So it's essentially the same type of concept, though, again. And instead of partners, it has members. So occasionally you'll see it they'll call them partners, but typically it's members. And the nice thing about the limited liability corporation is it limits the liability of the members. So kind of in a weird way, you can almost say it goes against what I was saying about partnerships, that there has to be at least one general partner. The limited liability corporation is a way to, like I said, since it's a hybrid kind of between the partnerships and a corporation, it's a way to limit the liability for everybody. It's something that's relatively new, relatively meaning, let's see, past 30, maybe 40 years at most, that came up. It wasn't used a lot right away because people didn't understand what it was for or what the benefits were of it. But now you tend to see it all over the place. The LLC, particularly for smaller corporations, you will tend to see that designation. There is a real estate limited partnership called a RELP. Imagine that, has an acronym for it, RELP. And it's a limited partnership entity organized to invest in real estate. Outside investors are sought to provide financing for the real estate project in exchange for a share of ownership as, again, limited partners. All right, to move on to corporations. Corporations, the legal entity that is separate and distinct from its owners. A corporation has been recognized by law to essentially be an individual. It can essentially do everything that an individual can do. It can hold property, it can transfer property, it pays taxes, it operates a business. It can't vote in elections. It can certainly vote as a member of a partnership or as another legal business entity. A corporation itself could, in a sense, sit on a board of directors. So it can do, like I said, virtually anything that a human can do. Very common in the US, of course. Most companies and most people are familiar with it, you know, that things are corporations. General Motors, corporation. One thing about partnerships before we get off that too is partnerships always have to be organized to do business, to have a profit. If they are unprofitable, that's a good reason for a partner to essentially sue in court to dissolve the partnership. Corporations, however, don't have to necessarily have a profit. For one thing, they can be a charitable corporation or organization. So that's something that a partnership cannot be charitable. It has to be made for a profit. The advantages of corporations are, of course, that the shareholders are not liable for any debts incurred or judgments handed down against the corporation. Shareholders only risk their equity in the corporation. So, you know, their shares may end up being of no value because all the corporate assets get seized or the corporation goes out of business. Corporations are able to raise additional funds by selling shares in the corporation. That's the whole principle behind creating a corporation in the first place, was a way to get funds to run the business or to invest in something or to buy something that they were going to do. So corporations were a very early type of legal entity to get together large pools of money to do larger projects. Corporation can deduct the cost of benefits it provides to employees and officers. That's not typically something that a partnership can do because all those costs and expenses are kind of flow through to the general partners. Some corporations are able to elect treatment as an S corporation, which exempts them from some federal income taxes, or treats them also more as under the footing of a partnership in the form of taxing. You don't tend to see the sub S corporation as much anymore. It's really a designation that's done by the IRS to ease tax liability, in a sense, tax consequences for like a small corporation, like a ma and pa corporation or a closely held family corporation. That'll be small, doesn't do, you know, as much business typically as a major corporation. So the shareholders are actually the family members or the husband and wife or whatever. And because of that, they lobbied Congress to set up a special designation. Now you tend to see LLCs kind of taking that role, the limited liability corporation, because you can have more people in that than typically you could have in a subchapter S corporation. So you're not seeing as many sub S corporations as what there used to be. Disadvantages of a corporation are just simply that sometimes it requires more time and money to form than other business structures. Government entities tend to monitor them more closely, which may result in added paperwork. Corporate profits are in a sense taxed twice. Income to the corporation is taxed, and then when that money is paid to the shareholders or whatever, that is income to the shareholders. So you could call it double taxation if you want. That's the reason why the Subchapter S corporation was set up, so there wouldn't be that double taxation. And that's also one of the benefits then of LLCs as well. They kind of go along with that Subchapter S taxation concept. Corporations, there's a requirement that there has to be 3 officers at least in a corporation: a president, a treasurer or chief financial officer, whatever you want to call them, and a secretary. It's possible to just have one person hold all 3 of those offices. So even though that one person holds all 3, that's still considered 3 officers. They're just all in the one person, because there are some Subchapter S corporations in particular that just have 1 or 2 officers, 1 or 2 holders of the whole of all the shares. Let's see. The corporations and LLCs are different in how they're taxed, as I stated. Because corporations are separate entities, they're taxed at the corporate rate, while LLCs are taxed based on adjusted gross income of the owners. So in that way, again, it's kind of a blend between a partnership and a corporation. So they get some of the tax advantages of kind of being a partnership, where the profits and losses are flowed directly through to the holders, to the owners of the corporation. So that's why you see a lot more LLCs coming about. And again, typically they will be of a smaller size. And that doesn't mean that they're necessarily small by somebody's standards. They are bigger than what the Subchapter S corporation typically would be. Well, let's see. A lot of my stuff, I can move. Some of this that I see is somewhat duplicative. So also, one of the things that happens with establishing a limited liability company or LLC is you protect the real estate assets from liability, such as lawsuits and credit issues, in particular of the owners. So again, it's the business entity, the LLC, that is liable, not necessarily the owners. There is a possibility of what they call piercing the corporate veil. It's actually very rare and typically hard to do, where what you're trying to prove in court is that the corporation is merely an alter ego for an individual, and that the individual really does pull all the strings and is just standing behind the corporation, kind of like in the Wizard of Oz movie. The piercing the corporate veil is moving aside the curtain to see that the wizard is actually just some guy operating a machine. And that's essentially the same concept with piercing the corporate veil. Typically, like I said, that's very difficult to do, so creditors and will only go against the assets of the corporation. Corporations, how are they designated? There could be an LTD standing for limited after them, or it could be, again, LLC. LTD as a descriptor is not a specific business entity in the United States. I think in England, LTD means a little bit different form of a corporation than what we have here. But as it occurs here, what typically you will see is for a corporation, you'll see like INC, or which is short for incorporated, or you might even see the word corp or corporation, or you might see limited or LTD or LLC. And sometimes they spell that out completely too, a limited liability company. And sometimes one of the clues will even be just company. It might just be company or CO, period.
Hey, Greg, I want to
Yes.
just pause a little bit because I want to hit to our next two sections of the trust and government entities. Before we go to that next, give you a chance to move to that area. I want to find out through Paula if we have any questions or
Oh, good
anything
idea.
of that nature. Gives you a chance to get to the trust area.
Hey, thanks for checking. No, there are no questions in the questions box.
Okay, great.
Great.
So let's hit to our last two bullet points there, Greg, because I know they'll fill that time going into trust and government entities.
Okay. I'll do that. The last thing I did want to say about LLC is a lot of LLCs are created for professional organizations. And again, if you deal in real estate, there's a lot of real estate companies now that are organized as LLCs. So hopefully it's not an unfamiliar concept with a lot of you out there, that you've seen it before. You may have worked for one or even started one. You may be a shareholder or a manager of one. So as I flip through to my set of trusts, here it is. A trust is simply something creating a person known as the settlor. SETTLOR gives property to another person, a trustee, to hold for the benefit of a third person who is the beneficiary. So in other words, the original person, the settlor, given property to another person to hold for the benefit of a third person, the beneficiary. And there could be a number of beneficiaries. There could be a number of trustees as well. It's a good way to hold and protect your assets for the future. We've been seeing a lot more of those that are like called a living trust or whatever. And you'll see in particular parents who are older, and we've discussed this in one of the previous presentations, where life estates are falling kind of by the wayside in favor of these living trusts, where it enables the parents to continue to live on the property while at the same time. And the nice thing about the trust versus the life estate is the parents are the trustees. They're both the settlor, the trustor, if you would, and the trustees. They've conveyed it to this trust. They are the trustees of the trust, so they could still sell that property. They still have the authority to sell the property. That should be stated in the trust document, however. That's the thing you want to see who has the authority, because it's possible that only one person has it, or it's possible that two people have it, or it could be in the situation where my two sisters and I hold my father's property, that it was two trustees must, at least 2 out of 3 have to agree and sign off on anything. That way, that kind of protects everybody. Or it could just be where there's a managing trustee that's designated. So, and that way you only need the managing trustee. But then that means the other trustees, one, don't have to sign and should not sign. And again, anytime that somebody is signing and in a different capacity, whether it's power of attorney or as general partner of a partnership or as an officer of a corporation or as a trustee of a trust, that should be designated, that should be identified. And it's also to their benefit, because you as an individual are liable for anything that you sign. You are personally liable if you sign in a personal capacity. So if you're signing on behalf of someone else, you want to let it be known that that's what you're doing, because you're not personally liable then. You're only signing on as that capacity for power of attorney or trustee. So the only thing you're liable for is maybe fraud. It'd have to be an actual crime that you're talking about. The trust agreement, again, should set out who the beneficiaries are and how the trust will be administered. Because the beneficiaries, again, like taking the example of the living trust with property, the parents who are the original trustees, they start out as the beneficiaries. Upon the death of them, then the children typically, or whoever they want to leave the property to, they are the beneficiaries and they become the new trustees. And the reason a lot of people are doing this is because it avoids probate. So the property isn't necessarily valued through the probate court and stuff. It's a simpler and faster way, and typically less expensive way, to transfer property to basically the heirs, what would typically be called the heirs, but now they're being called beneficiaries under a trust. And it was something, again, these type of living trusts pretty much started coming up in favor in the 90s, I'd say the early 1990s, and they've really taken off. You see a lot more of them now. Typically, they're called a revocable trust, and the reason that is because they're revocable, if you would, by the people that create them. Because again, remember, it's the original person, that's the trustor, conveys the property to the trust with them as trustee and beneficiary until upon their death, their children or somebody else become the beneficiaries. So until that happens, until their death, it's revocable. They can, in other words, sell the property off and the trust ceases to exist because there's nothing left in the trust. There are other things that can be put in the trust too as well, whether it be bank accounts or whatever, that type of thing. But typically what you will see in the living trust is it typically deals with real estate. And that's what, for our purposes, we tend to see as we go out through areas and have people sign off on the conveyance instruments that we have. Again, for summary, it comes out to who can negotiate and sign. Who has that authority? In a corporation, it's got to be designated by a corporate resolution or articles of incorporation. It's got to be a writing. You'll see that. You need to see that thing. S corporation, same thing. It's just another corporation. Limited liability corporation or company, LLC, same thing. You still need that corporate resolution or articles of incorporation that set out who has that authority and responsibility. In a general partnership, it's any general partner. Limited, though sometimes it may be designated specifically in the partnership agreement. And that's really, for the benefit of the general partners, that's the best way to do it, because you don't want just anybody, selling the property and then the other general partners asking what happened. Limited partnership, again, any general partner only, not the limited partners. They're only in it for their investment. They have no authority. So it's got to be a general partner that signs off. Limited liability partnership, again, the same thing, any general partner. And in a trust, it's got to be the designated member or managing member as stated in the trust document. And again, that could be more than one person. It could be, like I said in my example with myself, it could be 2 out of 3. So if that's the case, then you need both those signatures. Well, that's pretty much about it, I think, Wayne, for what I have to say. So,
okay. Fantastic.
Government entities, I guess I didn't cover government entities
Okay.
quickly,
Back to that.
to go. And that's, again, a pretty simple type of concept. Is a government entity, it should be, we talked about that before, there should be a resolution from a county or a township or an ordinance from a municipality, a city or village, that says who has this authority to convey the property. Again, that person is an agent on behalf of that government entity. So you got to make sure that that agent has the authority to bind the government entity. You don't want to just walk into an office and have any clerk sign off on it. Sometimes people don't understand whether they have the authority or not. So that you'll run into more with a township than you will with any type of larger type of entity. But it's pretty clear in most government situations who has the authority or who doesn't. So, but that's just again, the key to it is agency and principal. Who has the authority to bind the principal? Who has the authority to sign off on the document? That's the key. So that's it, I think, Wayne. That's
All right.
we're probably under our time.
We are by 4 minutes. And that concludes our session. So Paula, there you go with our ending presentation, our email address information that we have. And I'll turn it back over to you.
All right. Let's see. We have two things that came into the questions box. So one moment. Oh, so we have Michelle Miller. Michelle Miller said, we are also seeing POD&R in our deed in this area, pay on death, like a savings account. She just was making a comment.
Okay.
Yeah.
But that's it. That's all we had that was typed into the questions box. So everyone has the contact information. Thank you for joining.
Thank you.
Yeah.
Have a good day, everyone.
Thank you.
Thanks, everyone.